who took part in the process of constitution making. I'm happy to note that you, Your Excellency, you are a member of the Parliamentary Select Committee, and so was your Prime Cabinet Secretary. And of course, our former Prime Minister was a key player in the process. But on this side, we have the senior counsel on that end who was a member of the Committee of Experts, and her ladyship, the Supreme Court judge, who was also a member of the Committee of Experts. Those are the two organs that really process the Katiba in terms of the review process. So I'm going to ask Justice Njoki, who was a former parliamentarian, who is a lawyer of much repute, and who, during her time, championed quite a bit of the Bill of Rights. What she thinks really the Constitution has delivered for the judiciary, to the point where Kenyans think the judiciary ought to be celebrated. Justice Njoki.
Thank you very much, Chair. I think that the thinking during the drafting of the Constitution, that the judiciary was a subject matter, that there was trust deficit around the judiciary because most of the judges, or all the judges, were direct presidential appointees. The judiciary had no budget, and therefore Kenyans were very untrusting or distrusting. I think moving from the promulgation of the Constitution of Kenya 2010, we've seen many changes. We now see far much more decisional independence of judges, where judges fear not that night phone call from State House, as was in the dark days, where now we have seen more operational independence as gradually the judiciary is getting a little bit more funding, that is increasing staff. We are now increasing judges. The judiciary is now operational in 47 counties, and therefore access to justice, which was partially a vision of the Constitution, is now, we are on the journey there. There's also the issue of Kenyans who now come to the judiciary. And people say that Kenyans are very litigious. They come to court on every matter. I think that it should be celebrated. There was a time before the Constitution of 2010 when not all Kenyans could come to court. There was the issue, what we call formally in the legal language, of locus standi. But now, any Kenyan can come on any issue, and they are doing so. And therefore, I do believe that the Constitution is working, and the judiciary too.
Thank you very much. A round of applause for her, but I'll still be with her. And we said we're going to be transparent. So indeed, there are also those who see some challenges when it comes to the judiciary in terms of overreach of the judiciary. For example, the gentleman next to me, representing the executive, probably will say, they are having it difficult to run the executive because of overreach by the judiciary. There are those who would say that the judiciary has independence, it cannot be touched by any outside party, yet the judiciary shields its officers from accountability. What would be the remarks from the Lady Justice? And I understand you are a sitting judge and your remarks will be circumscribed.
I think that the Constitution is very clear in Article 10, where all the national values bind all state officers, those who work in the executive, those who are in Parliament and in the judiciary, that we must follow the rule of law, that there must be transparency, accountability, we must allow participation of the people. Therefore, it is the duty of the judiciary to be the guardian of the Constitution and to defend where any arm of government does not follow the Constitution. That cannot be judicial overreach. That can only be fidelity to the Constitution. There are many challenges, of course. We've seen that as we listen to some of the cases. There are a number of turf wars. You know, some of the cases that come before us, some are between Senate and National Assembly, others are between the national government and the county government. But those are disputes that we do resolve. However, there is a concern that sometimes political questions are brought to the courts, and courts cannot answer political questions. Courts may only answer judicial questions and points of law, and perhaps therefore, the political class ought to be encouraged to resolve political disputes outside of the corridors of the courts.
Thank you very much. Let me go on the other side.